Don't forget, you can reach the latest episode of Potomac Watch anytime. Just ask your smart speaker, play the Opinion Potomac Watch podcast.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. Let's also talk about a couple of Supreme Court cases that came out on Thursday. First one involving everybody's favorite government agency, the Internal Revenue Service. I know the IRS always competing with the TSA for the most popular among the American people. But this case involves a delinquent taxpayer that the feds say owes about $2 million in taxes and penalties. And so the IRS agents are searching for his assets to satisfy that assessment. And they send some summonses to big banks, Wells Fargo, JP Morgan, Bank of America, asking for the bank records of this taxpayer's wife and a law firm where he was a client. And IRS did not notify his wife or the law firm that it was asking for their records, which legally means that they did not have any right to object or to challenge that in court. And the question for the Supreme Court is whether that's okay, whether the IRS is following the law. And remarkably, the answer there is yes. It is a unanimous Supreme Court. Normally, the IRS is required to give notice when it sends these kinds of summonses for records, but no notice is required when the IRS is acting in aid of the collection of an assessment against the person with respect to whose liability the summons is issued, is the language in the law. And a unanimous Supreme Court is saying here that that is very broad language. A summons being sent in aid of the collection of an assessment covers looking for whatever canceled checks this guy might have paid the law firm where he was a longtime client. And it's a unanimous Supreme Court. Here's a piece of the opinion from Chief Justice John Roberts. He says that even if the summonses did not reveal bank accounts in which this taxpayer has illegal interests, they could lead to assets parked elsewhere. And notable that the Supreme Court also has a big chunk here where they acknowledge the privacy concerns that people might have about this. Remember, there's no allegation, at least in this case, that this law firm has done anything wrong or was in any way involved with this tax evasion that the IRS is going after. And Kate, I think this is a fascinating case because it's unanimous. And the justices seem to signal that it's clear that it might be unpopular and the law might be clear, but there are occasionally these Supreme Court cases where the law is clear and Congress then acts to change the law because there is such a backlash to it. And I wonder if we might be seeing one of those now.
Yeah, well, first of all, I think it is the normal categories that we usually hear about the Supreme Court, which is that, it's devolved into a partisan institution. But this shows that there really are areas of agreement. And that's really quite true of a lot of cases. You don't hear about most of the cases that they're deciding. But I think to your point, this is something that Congress should take a look at pretty urgently because it seems like there would be pretty broad consensus and the IRS always makes for good political fodder.
Speaking of defying the political Supreme Court narrative, there's also a concurring opinion here by Justice Ketanji Brown Jackson on the left and Justice Neil Gorsuch on the right. And they want to add that even though they joined the majority's opinion here, they want to add that the IRS's power is not without limits. And they give an example of a summons to a taxpayer's dry cleaner seeking years of the dry cleaner's financial records. The agency might believe that having the entirety of that business's financial information would aid its tax collection efforts, even though the taxpayer has no known financial interest in that business or any special relationship with the business's owners. And they go on to explain that the IRS could be trying to figure out what credit card the taxpayer uses when he goes into the dry cleaner because maybe he has credit cards in different names. And that is something that Justice Jackson and Justice Gorsuch think might be unreasonable. And maybe there's room for the Supreme Court to come back later and add some kind of reasonableness test to this. But the majority does not go there, at least in this case. So, Kim, I find myself wondering again whether this is something that Republicans might take up. They have a lot of grievances against the IRS and President Biden's plan to expand the IRS. They are already making political hay on that topic. And I find myself thinking that this is something that could easily slot into a bill on that subject.
Oh, absolutely. And by the way, when I read that concurrence by Gorsuch and Jackson, it felt to me as though they were actually giving a few hints to Congress saying, look at the ways that this could be abused. If you're seeking to change this law in some way, you may want to take into account some of these different things to make sure you do a better job next time you write it. But this has already been a kind of issue for Republicans prior to now, really going after not just the IRS's authority, but other pieces of the federal bureaucracy and their ability to also engage in what's known as civil forfeiture, where they can essentially take your assets on very low bar on how they can do this. That has been a concern. It certainly is something that really riles the public when they hear about it. And you add to that just the other things that have been coming out of the IRS, obviously all the money that was given to it as part of the Biden bill last year that's going to turbocharge the number of agents that are out for collection. And some other issues, the leaks that have come out, their inability to protect confidential taxpayer information. This is not a much loved agency. And even though this is unrelated to the question of Biden's IRS funding, in that was very much aimed at supposedly wealthy tax cheats, as you were, the very notion that the agency has all this extra dollars to now pursue some of the cases that were exposed by this Supreme Court litigation, I think is going to be a very easy layup for Republicans to continue fueling frustration over this agency.
The other outcome I want to mention is a pair of cases, one involving Twitter and one involving Google, that related to ISIS terrorism. One of them involved attack in Istanbul, Turkey. Another one involved attacks in France. And the basic argument in both of these cases was that ISIS used these internet platforms to recruit and potentially to radicalize people, that the algorithms on these platforms, the way that they sorted content, may have served ISIS content to people who would be interested in ISIS content, because that's how those kind of algorithms work. It was, again, a unanimous Supreme Court. Justice Clarence Thomas writing that these platforms did not aid or abet ISIS. And here's a key piece. It might be that bad actors like ISIS are able to use platforms like defendants for illegal and sometimes terrible ends, but the same could be said of cell phones, email, or the internet generally. And I think that's a pretty good comparison. The phone company is not liable for the fact that people consummate drug deals by text message or by phone. And Kate, part of what I think is so interesting about this case is the media story around it, because before this case was heard, there was all sorts of sturm and drang that the justices were going to break the internet. And I have a pair of headlines here that I want to call out specifically in the New Yorker. So here's the one before the argument was heard: 2 Supreme Court cases that could break the internet. And then after the argument was heard, after the justices seemed to signal they were skeptical of these claims, here's the New Yorker headline: the Supreme Court probably won't break the internet, at least for now. And Kate, I just find this so funny. There's often cases that I'm skeptical of legally. The recent case against Obamacare was another one that get huge media attention because of the way that they are framed. And then come to find out, nope, it's a unanimous court goes the other direction.
Yeah, Kyle, I mean, the doomsday predictions remind me a lot of covering the repeal of net neutrality, obscure communications policy, where there was all these predictions that the internet was going to be over and unavailable. And of course, it didn't happen, right? And it's just shocking that there's very little accountability for those kind of predictions. But I would add on this case, I was so surprised that the cases were so thin. The person who committed this attack, for instance, it was not even a claim that they were using these platforms themselves. It was like a very attenuated claim about how these platforms are used and how people are steered towards certain things, that it really just was not going to be able to clear the legal bar of actually, assisting in the crime, right? So to me, I was surprised really that this is the best case that we found on this, because it was just so thin.
And there are going to be future cases on this as well. I should mention, this does not relate to the Section 230 immunity that platforms have been granted by Congress. And so there will probably be future litigation over how that immunity protects these algorithms or not. But until then, I guess we will have to await the next headlines about the breaking of the internet. Thank you, Kate and Kim. Thank you all for listening. You can email us at pwpodcast@wsj.com. If you like the show, please hit that subscribe button, and we'll be back next week with another edition of Potomac Watch.